The documents, and everybody's familiar with these, is the will, maybe not so much a trust, financial power of attorney, healthcare advance directive. These are typically documents that clients put in place, whether they go on LegalZoom or go to a lawyer or go online or however they end up trying to find those. They will put these in place and then think everything's kind of good and done. And the problem is, having the document in and of itself is not the solution. It's really kind of looking at the family dynamics and the situation and trying to plan through that. So, I don't want to disparage, of course it's self-serving to say everybody should come to a lawyer. I'm not really saying that. What I'm saying is there are a lot of clients that come to me and they have documents in place and they really don't know either what the documents say, the documents don't really accomplish what they're telling me their intentions are. I tell them what the document has, and well, I didn't know that. So it's just, there's a consultation, I would say. I think a lot of folks think as lawyers is just just give me the form and the document, let me sign, and that's not really my role. 95% of my role is consultation. So this is one that's kind of foreign to a lot of people, and I just want to explain it because it has a big application in my practice for a lot of reasons. And that is, when you talk about trust, there's kind of two big types. There's the revocable trust, which is usually done to avoid probate and to manage assets more easily. It's changeable, revocable. It's more of an estate planning deal. The other one is an irrevocable trust. So that's what I'm going to speak on here. So this is a little bit scarier, perhaps, for most of us that are younger, but maybe not so scary when you're in your 80s and 90s and you're looking at the alternative of not putting something like this in place. So this is somewhat an irrevocable trust, would be an alternative to power of attorney or will. So I'll give you the scenario. So a client comes in the office and he or she, for guys, sorry, about 7 out of 8 times it's the women that are surviving, but occasionally it's the men. But they will come into the office, the mom and a lot of times kids, or one or all of them, and they'll usually have one or two paths. Either it's, well, we don't want the government to get all of mom's assets, so we want to do some planning. And that's a whole different conversation. That's a VA Medicaid eligibility kind of a plan. Typically does nothing for the senior, although there are some scenarios where it could benefit the senior, but generally it's a preserve the inheritance for the kids kind of a plan. So that's not really my focus here, but that is how this gets used in many cases. The other conversation that sometimes happens is a parent, or if you motivated by the child, says, well, and it's usually the sibling of this child that's not in the room, the black sheep, whatever you want to call it, is, well, Johnny's been living with mom, never left the roost, the nest, and she just enables him. She just gives him money, he doesn't work, it's just on and on and on, and she can't say no. All right, and then mom's sitting here, and I'm talking to her, having a conversation with her, and mom says, yeah, I can't not help him. This is going on or that's going on. But I see that it's draining my finances. I can see that I don't have enough to maintain for the rest of my lifetime, or whatever her rationale is, that motivates her to get here. Usually it's the daughter or one of the other kids that are motivating that. So one plan might be, well, Mom, are you comfortable with the daughter controlling all of your assets? Well, yes, she does that now. All right, well, perhaps we take the assets out of your name, put it into a trust. The daughter's the trustee, and the trust says it's going to benefit you for the rest of your lifetime. Now, it kind of does two things at this point. One, it's Mom now legally doesn't have any control of those assets. Now, that's not usually too scary to her because practically she hasn't had the access anyway. I mean, daughter's handling all the payments, she's managing the money. Mom can't even tell me what she's got in her name. Which to the detective in the room that'll be speaking a little bit later, that's the scary part about this whole thing is, yeah, well, Mom, that's how the vulnerability occurs and that's how the opportunity exists. But this is a scenario to where we're saying in this trust is only going to benefit Mom for her lifetime. So daughter can't divert the money to herself or someone else. What it does for Mom and the son's dynamic is the son then comes to the mom and mom says at this point, well, you got to go talk to your sister. Now, that can be awkward, but it's certainly at that point the sister's not going to do what the mom's been doing. And mom still gets her income, and if she wants to give that to the son, I suppose she could. But what this does is sets up an opportunity to where you've got mom taken out of the equation, because I don't know if you guys have seen it, but some parents just can't say no to the kids, and at the detriment of their own selves. The other thing that this will do, and this is one of the difficult parts for me when I'm trying to do planning, is as someone ages, their ability to process, their ability to, understand or appreciate vulnerability and manipulation and all those things, it gets tested. And there are these many situations where a parent says, they've had a will or a document in place that says, I want everything to go equally to my 3 kids for decades. And now they're late stage in life and they want to just give everything to the daughter. And I'll usually say, well, why? And my reason for why is because there may be a reason they're doing it that we can overcome without, an inequitable, balance among the other children. I kind of explore the why, but many times it's she needs this. The others don't need it. Might be vulnerable to a transfer late in life. It prevents that from happening. And it's a legal obligation, so whoever you designated as a trustee is legally obligated to follow those documents. So it's not that they can go off on a tangent and do what they want. They don't have the discretion. If it says for mom's benefit for a lifetime, that's what it's for. And then when mom passes, if it's equally divided among the kids, that's what they have to do. All right? And there's a legal obligation for that. So this is just real quick. I have a lot of problems that get imposed by parents trying to do right. For some reason, whether it's Susie Orman in California, she's a great person, but California's a lot different law than Georgia. She just completely says you want to avoid probate at all costs. Well, Georgia probate's not that comprehensive or that problematic. There are circumstances where we absolutely do want to avoid probate, but not as a just general mass rule. Well, the perception of a lot of people is that they want to avoid probate. So, but their overall arching rule is avoid probate at all costs. So what they do is they go to the bank, and the bank says, sure, we can add a transfer on death provision on this account, or we can add your daughter joint with right of survivorship on the account, or beneficiary designation on an IRA or life insurance. That'll avoid probate. Right? That's what the advisors tell them. And it's true. Those assets are not going to be subject to probate. And here's what a lot of people do. They will do that to try to avoid probate, and then create a will, and the will says everything goes equally among my children. And I would tell you 60% of the clients that I meet with think that will is kind of this overarching controls everything. But it doesn't. It doesn't control these things. It only controls what's in mom's name only when mom passes away. So if it's a car or a house, that's going to be controlled by the will. But if it's a $350,000 brokerage account that mom's name payable on death to a child, it's going to go to that child. So a lot of times mom will do it trying to avoid probate, and then so when I do the estate plan, we're kind of looking at all the assets and all the ownership and how everything is set up. It's not just, let's do your will that says equally among the kids. It's looking at everything to make sure they tie together. So when we look at it and I say, well, but you've got this life insurance that's beneficiary designation just to one child, but your will says equally among the 3. Why is that? I would tell you most of the time they tell me, well, yeah, my daughter knows that she's going to receive that and then divvy it up. Yeah, I'm sure she means well in saying that and she's not trying to mislead you. However, many things happen in life. And the 2 things I see is death or incapacity, right? Or she doesn't tend to do that until mom passes away and then mom's jewelry's missing. Or the 2 days after mom's passed, the brother's coming in saying, hey, where's my share? And it just, and it offends, and it just starts to, people start to get sideways pretty quick. So my plan is always, let's not leave it up to someone to fulfill your intentions, let's just make it clear. So those have a place in some of the plans, but not as often as people seem to implement. So this is just some additional things that I would recommend to clients. So the first two is basically the scenario where mom wants to move in with a child, and that child is the responsible child, and that responsible child feels really awkward about charging mom. And what happens is, mom lives in the house with them, they do all these things to take care of mom for 10 years, and then mom needs 24-hour skilled care, and they come to me to want to see what about getting Medicaid or VA benefits, and I say, well, y'all done an awesome job preserving mom's money and resources all these years, but that's a countable resource, and now you got to spend it down before you can get those benefits. Well, that's not fair. Yeah, well, while mom was living with you, maybe you should have been charging for services or charging for rent or getting paid those reimbursements. You don't have to stick them in your pocket. Just put them in a separate account. We'll call it mom's. So that it's still hers, but for purposes of VA or Medicaid eligibility, it's not counted as her resource. So that's a big helpful for clients. The distributing personal property, I have no idea why someone that's 90 years old that does never wear her jewelry, why she won't give them to the kids or grandkids. Because what I would say happens more times than I would like to recount, mom passes away, buried, memorialized, and then it's weeks later, and well, where's the jewelry? Where's the jewelry box? No, they don't know. Was it a care provider? Was it a sibling? Was it the guest that came in the house? Was it where's it? So, like, why even leave that to chance? Why not get it to where you want? And if you've never been through a process with type A or red siblings and trying to divvy up a parent's assets, you don't want to do that if mom can help facilitate that before she passes, or dad, obviously. And then just the accounting to everyone. So if a child's going to do something like charge rent or charge for services, put it out there. Let everybody know what's going on. Now, some families that just is not possible, but for many of you.